case of Foodrise Ltd, formerly Global Feedback Limited, against His Majesty's Treasury and others.
Yes, Ms. Wakefield.
May it please the Court, I appear on behalf of the appellant, Foodrise, together with my learned friends Mr McCarthy and Mr Mitchell. The respondents, His Majesty's Treasury and the Secretary of State for Business and Trade, are represented by Sir James Eadie, King's Counsel, Mr Birdling, King's Counsel, Mr Howell and Mr Riley. Subject to your views, we've divided the time up between us so that I will sit down just before the short adjournment at 12:45. You'll then hear from Sir James until 3:45 and then I'll have 15 minutes in reply. And the structure which I propose to take in my submissions is to start by addressing domestic law, sometime on my learned friend's construction and how it maps onto domestic law, and then I'll address my construction and how it works in domestic law. Once I've done that, I'll turn to the Vienna Convention exercise. There's an awful lot which could be covered there. I obviously haven't got much time. So what I'll seek to do is take you through the materials at a relatively high level, addressing in particular the points made by my learned friend against me in his written case. And we'll go through the convention, the main cases, the Aarhus Convention Compliance Committee, the Travo, the implementation guide. And then finally, to the extent that I've not done so already, I'll quickly set out how it is that my application for judicial review falls within the Aarhus Convention regime and does so, I say, very comfortably. So if I start then with the competing interpretations as they apply in domestic law, the first point which I'd like to emphasise is one of the key new points in my learned friend's written case, namely that Article 9.3, he says, does not cover claims in which there is dispute about the provisions of national law relating to the environment. So to situate that point, we're in a judicial review, quintessentially focused on legal argument, and Sir James says that any dispute about the provision of national law relating to the environment means that the claim falls outside Article 9.3.
Just for our notes, where in the printed case?
That's where I'm going to now.
All right.
So if we go to the key documents bundle, page 80 to 81, this is the first time we see the argument emerge, and we see it in various places. Paragraphs 29 to 30, and we see in 29, by the hole punch for me in a hard copy, the end of the beginning of the paragraph, the nature of the legal provision, which is said to have been contravened in the abstract. And if we go down to subparagraph 3, it's sufficient for a claimant to allege a contravention of a national law which can, at the outset of proceedings, be definitively characterised as a national law relating to the environment. That's definitely characterised. However, Article 9.3 is not applicable to alleged contraventions of alleged provisions of national law relating to the environment, or 2, provisions of national law allegedly relating to the environment. And it said that that would give it an absurdly broad scope which has no basis in the text. So the first words alleged, which are accepted, I think apply largely to factual disputes. And the kinds of allegations which are said to be out of scope of 9.3 are legal argument. Now, the cases which are relied on in this regard, in subparagraph 4, that's at the top of page 81, none of those support the proposition in relation to which they're relied upon. So the McMahon case, that related to the difficulty in applying the Austin test of significant public environmental benefits, where you don't otherwise need to. So, of course, that Austin test is in the context of private nuisance. And it was said in McMahon, well, that raises difficult judgment calls, so let's not apply it when we don't need to. That's a different point. The White and Plymouth City Council case was an application for contempt in relation to an injunction made in anticipation of judicial review proceedings. The proceedings became academic because the council chopped the trees down. That was relied on as an argument for resisting Aarhus cost protection, and the learned judge unsurprisingly said, I'm not going to decide it by reference to those facts, but by reference to the legal framework. And then the North East Pylon case In that case, the Court of Justice was rejecting an argument that cost protection should only be available where there's both an alleged contravention of national law relating to the environment, i.e. 9.3, and also damage to the environment. So it was rejecting that supplemental condition. So none of those three cases support the proposition for which they're tendered. If we go to paragraph 98 sub 3...
Isn't it a reasonable point that it should be capable of being ascertained at the start of the proceedings without having to make extensive findings whether the claim comes within the convention or not?
It
may not follow from that you can't go on the basis of allegations, but you do have to be able to apply the test, don't you, without investigating the issues.
You do, absolutely, my lord. So one should look at the pleadings, the JR claim form, see the legal argument, and form a view on whether that legal argument, as described, falls within 9.3. Is it the right
character or not?
Absolutely.
Yeah.
And it's not enough for Sir James to say, I disagree, to mean that he wins, if I put it that way crudely.
So in effect, as I understand your case, you accept that you have to have pleaded a case which, if you compare the pleaded case with the convention, falls within the scope of Article 9.3 in order to attract the cost protection.
I do.
But that it's sufficient that that's the case being alleged. One can't leap to the end and have to work out whether it's arguable or not arguable, in effect determine whether it's a good case or not a good case right at the outset.
That's exactly my case.
Yes, all right.
And it may be, in the light of that exchange, that I need to spend less time on the subsequent places in which this pops up. But just for your notes, paragraph 98.3, which is on page 107, so here we're dealing with material considerations imposed by statute, but which would require a degree of statutory construction to elicit. And we see in subparagraph 3, page 107, again, that the court may, here we see the effect of the appellant's case is that the claim must be held to be within the scope of 9.3, even though the court may decide at the substantive hearing that there was no requirement to take into account environmental considerations at all. Yes, that is my case. That's absolutely my case. And we see the last sentence, 9.3 does not apply to alleged contraventions. And again, we see alleged underlying national laws.
And of course, at that stage, I mean, you're only going to get permission if it's an arguable case.
Of course.
So the argument proceeds on the basis you've got an arguable case that there is a relevant breach of domestic law. You might lose at the substantive hearing, but the question is whether you get cost protection in order to bring that case.
So that's right for the hypothetical situation that's posited here. Aarhus cost protection arises even in relation to claims where permission's been refused.
Right. Okay.
And that's one of the points that's made against me. And though in that situation, the choice is either there be no cost protection, which is the result urged upon the court by my learned friend, or I say that there is cost protection even though permission's refused. And I say that's essential because when one pleads these claims, one has to do so knowing that there is a robust and reliable cost protection regime, even pre-permission. And that's one of the distinctions between Aarhus and the standard JR cost protection regime.
But it will just be McCook cost protection.
It will be, absolutely. Well, it will be in relation to the Cook costs. So it will be the 5,000 or 10,000 multiplied by however many claimants there are, and the cost risk is Cook. So in most cases, it may well be thought, and your ladyship doubtless is going there, that the cost exposure will be beneath the Aarhus cap in any event. Not always, but in many cases, because it's only the acknowledgement of service costs.
Yes.
And then for your note, paragraph 99, sub 3, page 108.
Sorry. I follow all of that, but it also remains the case that, as I understand it, you're showing us that Sir James's argument on disputability and disputable questions not falling within the scope of Article 9.3 would apply in a case where permission is granted.
No, absolutely, that's his core case, absolutely. That he says the policy actually isn't sufficiently infused with the magic Venn purpose to fall within 9.3, so you're out, or it's a consideration which need be taken into account only on a rationality basis rather than infused with Fewing's 1 or some other kind of statutory matrix purpose. We have a row about that on the pleadings, and that means that I don't get cost protection.
Yes, thank you. Was there any other point in Sir James's case that you just wanted to draw our attention to how this argument?
In that connection, just 99.3 and then para 110.5. So 99.3 is on page 108, but this time in relation to policies. And then 110.5, this is at page 115, that's in relation to my case. So they deny that section 28 of the Act imposes the obligation to have regard to Article 4.1f of the UNFCCC, and they say for that reason they win. Amongst other reasons, they have alternative reasons, but just because they disagree with me. So that's point one. This didn't feature in the Court of Appeal's judgment, but it's in my learned friend's written case.
Can I just check, was this argument presented in the Court of Appeal?
No. So in the Court of Appeal, there was a lot of discussion about making things simple for the permission judge, which is obviously very important. The busy permission judge has to work through these papers quickly and form a decision quickly. I say that speaks in favour of my construction when we get to it, namely breach of any legal requirement which had to be complied for in order for the decision to be made lawfully, where that requirement relates to the environment. That's my case. That includes policies, obligations emanating from policies, includes public law principles. So I say that's simple. The approach of the Court of Appeal and my learned friend in relation to the true scope of 9.3 is very complicated. We'll work through some of it now, but the various different issues it could throw up.
Yeah, so I wasn't seeking to suggest it wasn't open to suggest. I just wanted to know, was it?
It wasn't, my lord, it wasn't. But I apprehend that the purpose of the argument is to say, well, this is simple, guys. This is how we make it simple. But
right, by saying even if you've got an arguable case, just because they've argued it on the other side, you're out.
Yeah.
Okay.
It is simple.
It certainly would be simple, yeah.
So turning to the application of my learned friend's approach to 9.3 to domestic law, and as I say, it's complicated. We have what I have been referring to as express statutory provisions. There's resistance to that characterisation, so I may be wrong, but a statutory provision which has some discernible, sufficiently bespoke purpose or object of environmental protection. That could be the vires. It could be a provision which it said the decision contravenes, but the provision is something like, you must do an environmental impact assessment. It's something very stark. And those, on my learned friend's case, fall within, and they do on the approach of the Court of Appeal as well. The vires point is perhaps particularly important because it's via this mechanism that we otherwise get public law principles into play. So when the Court of Appeal accepts, and it was my learned friend's case as well below, that a claim alleging that a national law relating to the environment has been contravened through a breach of public law principles, that falls within 9.3.
You were reading from, what were you reading from? Is this from?
Is in...
is it Court of Appeal or Respondents' case?
It's in the Respondents' case, paragraph 96, page 105, but it comes two times in the Court of Appeal, I think 63 and maybe 110, something like that. My learned friend, Mr. McCarthy, will give me the references. But it's common ground, essentially, that if you are in that sort of express statutory context, the vires say, or an express obligation to take the environment into account, if you perform that obligation or exercise that vires in a way which is incompatible with the public law, that falls in scope of 93. But you have to meet that first threshold test. You have to show that there's that statute, that provision, saying, I relate to the environment in really stark terms, imbued with parliamentary purpose. If we move away from what I've been calling express provisions to statute still...
So just as you say that their argument on this point is you need, in effect, a provision of national law which is expressly concerned with the environment, so it sort of bears branded on its forehead.
Exactly.
I'm a law about the environment.
Absolutely.
But that they accept that there may be a breach or an associated breach of the law in relation to that for general public law principles as they fall to be applied in relation to that provision.
That's absolutely right.
Okay.
That's absolutely right. And it may be that the word environment isn't used. It may be that the word used is climate change or recycling, or it may even be that one can discern a sufficient parliamentary object in relation to the environment that sometimes could bring other things in. But essentially it's express. That's what you're looking for, something really clear.
I thought their case, well, we'll hear from them what their case is, but it's not confined to statutory provisions. It could include rules of case law, for example, if our law, is not embodied in statute, or it can include policies in the Venn case.
It can include common law.
Yes.
Prerogative, they say, is out. And policies are in only if the statutory framework meets the Venn pattern. Now, the Venn pattern is relatively hard to pin down. We'll be going to Venn, unsurprisingly, in due course. But it's read by the Court of Appeal, Venn is read by the Court of Appeal, as relatively confined. Now, it may be the way of curing that is to say that's a misreading of Venn, and in fact, many policies relating to the environment have an important role in the national legal framework, and that's what the Court of Appeal was saying.
Well, can you summarise for us what the Venn pattern is? That's your phrase, I think.
So the Venn pattern, essentially, Lord Justice Sullivan said, first of all, I'm going to ask myself, how important is the planning regime for environmental protection generally? And he said, it is important. But he reached that conclusion by reference to environmental impact assessments and a different statutory obligation that says climate change impacts need to be taken into account. So that was a fairly broad brush, standing back kind of assessment. That's in paragraph 15. Then in paragraph...
of Venn.
Of Venn.
Yeah.
Then in paragraph 16, he says, domestically, much of our detail of environmental law is included in the policies, in policies in the planning regime. So planning regime in general, how much detail do we find in the policies? And then he concludes in paragraph 17, essentially, we would lose so much of that material from the scope of 9.3 if I said that policies didn't fall within national law, that I say that the combination of statute and policy in the planning context forms our national law relating to the environment. Now, the Court of Appeal reads it more narrowly than that. So they say, well, it remains the case that many Section 70 sub 2 considerations would fall outside Article 9.3. That's different from how people have generally understood Venn.
And I'm sorry, I'm going to keep asking you for references. Where does the Court of Appeal say that?
That is in... Let me open the Court of Appeal's judgment.
It's just for our notes so
Yeah,
that we can follow what you're saying.
No, of course, of course. So the Court of Appeal addresses Venn in 138 to 141, but the reference I just made is at 106. Sorry, I misspoke. It says here, it should be remembered that in Venn, the only provision of national law which the claimant said had been contravened was Section 70 sub 2.
Sorry, where are you reading from?
Paragraph 106 of the Court of Appeal judgment, page 180. The decision in Venn leaves open the possibility that a claim for judicial or statutory review in a planning case may be based on other provisions of our national law which do not relate to the environment.
There's missing not.
Do relate.
Sorry, do relate, that said.
There should...
You think it means not, do?
I think it means not. Otherwise, it doesn't make any sense. But in terms of the specialness of Venn, if we go to 140 and 141, which is at page 186.
It might mean what it says, that.
Yeah.
It might mean what it says.
Yeah,
It might do, but if we
I
go
think
to
we should assume it does, unless it obviously doesn't.
Yeah.
if we go to 140 and 141, we say in 140, the court was able to infer that Parliament intended that environmental protection would be achieved through these provisions combined with relevant policies for the protection or regulation of the environment. And then, however, it cannot be assumed that the court's reasoning in Venn, which was specific to the nature of the well-established role played by the planning regime in environmental protection, is transferable to open-ended statutory requirements to take into account relevant considerations in other legislation enacted for non-environmental purposes. So this is the limiting the reading down of Venn. And how the Court of Appeal approaches the issues in our case, and how it's understood, that maybe this is a misunderstanding of the Court of Appeal, is that when one has a general statutory obligation to take into account material considerations, even if, on the facts of that case, that statutory provision operates to generate fewings 1, so an implied mandatory consideration, or fewings 3, with the credence so obviously material overlay, so obviously material that you have to take it into account in accordance with the intentions of the Act. Even if it generates those two statutory obligations, it's outside 9.3. Now, that is a very important part of the judgment of the Court of Appeal as it's understood and as it's defended by my learned friend, because that means, stating the obvious, that when one has those general obligations in a statute, as we do in my statute, in section 28, even though they operate to impose a mandatory obligation, that doesn't count. And that is an extremely, extremely narrow reading down of what could be meant by parliamentary purpose. And I say it's wrong to think that only an express enumeration of factors, the draftsperson setting out in Annex 1 some kind of American-style contract of 150 pages long of each possible relevant consideration one could take into account, that would count for 9.3, but when instead, in accordance with conventional parliamentary drafting, we have a general provision, it doesn't count. And I say that's the same whether we're in fewings 1 or fewings 3, because although fewings 3 operates by reference to the principles of rationality, it does so in the context of statutory construction. And we see that in the judgment in Creed NZ, which is, of course, one sees all over the place, not least in the judgment of Lord Hodge and Lord Sales in the Friends of the Earth case here. But the quote from Creed NZ, which is set out, we don't need to go there, paragraph 116 to 121 of Friends of the Earth, notwithstanding...
Sorry, what is that reference?
So,
You want to give us the reference a bit more?
give you the reference more slowly.
We can know what you're talking about.
And a little bit slower. I'm struggling to keep up.
Yeah.
Sorry, I'm going too quickly. Conscious how much I have to get to.
I know, but
You'll miss your target if we're not following.
Exactly. If you go too fast, do another bit.
Spend the time wisely. So, in your Lordship's judgment in Friends of the Earth, you address the nature...
This is the Heathrow Airport case, is it?
It is.
Yeah,
exactly
Right.
that.
And I think you were giving us some paragraph references to that judgment.
I was.
Can you give us the bundle reference so we can follow
Yeah,
where you are?
absolutely. So it's page 2059. The relevant paragraphs are 116 to 121. And essentially, your Lordships endorse the well-known fewings characterisation, which I referred to without introducing. So I'll refresh our memories. Fewings 1.
Where do we go for this in the judgment? Sorry.
In Friends of the Earth, it's at 2059.
That's where it starts, but then where do we get the bit you're talking about? Somewhere around 2090?
Yeah.
Yeah, 2090.
Yeah.
So, paragraph 116 sets out the three categories of consideration as elucidated by Lord Justice Simon Brown in Fewings. So, Fewings 1, those factors which are clearly, whether expressly or impliedly, identified by the statute as considerations to which regard must be had. Second, those clearly identified by the statute as considerations to which regard must not be had. And then third, those considerations to which the decision maker may have regard if in his judgment and discretion he thinks it right to do so. And then 117, the credenzi, I may be saying that wrongly, overlay for the third category of fewings.
Right. But in some ways, that's saying that the boundary between what you're calling Fewings 1 and Fewings 3 can be a bit porous, because in some circumstances, in fact, in particular context, what might in other contexts be what you're calling Fewings 3, i.e. an optional consideration, will become a mandatory consideration if the circumstances are such that they make it so.
Absolutely, and we see that in the language at the bottom of paragraph 117, set out from credenzi, would not be in accordance with the intention of the Act. So it's still statutory construction, but by reference to common law principles of rationality. And those are, absent the then fact pattern, those are out of the Court of Justice's, of the Court of Appeal's approach to 9.3.
And that's the burden, I think, of paragraphs 142 and 143 of the Court of Appeal's judgment. Is that right?
That's right. And in fact, you'll see in paragraph 136 of the Court of Appeal's judgment, they address Friends of the Earth, which we've just been looking at.
I'm sorry, I missed the paragraph number.
136.
136.
They omit Fewings 2, so considerations you can't take into account. And so their first is Fewings 1, their second is Fewings 3, with the rationality overlay, and their third is Fewings genuinely up to you.
Right, so I think that they're treating the third category is breaking down into two subcategories, if you like.
That's
something
right.
where it remains optional for the decision maker, but secondly, in some circumstances, it would be irrational for the decision maker to treat it as anything other than material.
Yeah, absolutely. So those fall outside, and my learned friend says that's right. I think relying in part on his gosh, it's going to take some argument either way, and if we're having an argument, it's out, that first point. And secondly, I think in relation to Fewings 3, though he'll explain his case, I think because of a general objection to anything that arises by way of the common law or public law principle. Then, moving to policies. So absent the then situation, I think that both my learned friend and I understand the Court of Appeal to exclude all obligations which arise in relation to a policy. And I think that extends to policies which have some associated statutory obligation, provided that the statutory obligation doesn't say, make an environmental policy. But a general obligation to have regard to a policy would be out, even if the policy clearly said on its face, I relate to the environment. I'm all about the environment, guys. You'd need the statute to be the thing that refers to the environment.
Right. How does that work in the planning context? And when you have the National Planning Policy Framework, I mean, that's a policy.
Indeed, that they accept that Ben is correctly decided. So.
Yeah.
But I mean, there are two things in planning. One is the plan itself, which isn't a policy. It's a plan, and that's made in material consideration by Section 70, subsection 2, I think.
2C, yeah.
Yeah.
Oh, no, A when it's finalised.
But there is a policy overlay of the National Planning Policy Framework, which also applies, but that's a policy. So is it really right that on the, well, Court of Appeals analysis or the Respondents case, they're excluding all obligations in relation to policy?
I think that they would say that falls within the then world. So anything to do with whatever the proper scope of then and planning is in scope. But were there to be an equivalent to the MPPF?
Right. I appreciate it's not your case, but it's a bit difficult to see the logic.
There's no logic.
No.
There's just a need. There's a need to seek to distinguish then, and the way of distinguishing then is essentially saying then's to do with planning, I think, but that's entirely wrong. I think when one elicits the right principles from the Court of Appeals approach in then, what we see is an extremely pragmatic approach to where obligations in relation to the environment actually lie in national law, and across national law, one finds those requirements in policy. And it's really startling to say that when one has those policies, regardless of the vires pursuant to which they're made, imposing on their face obligations in relation to the environment, yes, they're policies, so they can be departed from. This is the point against me. We all know how policies take effect, but they are part of our national legal framework in relation to the environment, and suddenly they're out.
Well, unless in some sense it's planning.
Unless it's planning.
Yeah.
And unless through expensive and detailed legal argument, one can in each case expand the scope of the then principles, whatever they're properly viewed as being, to the statutory matrix in which one finds oneself to be arguing.
I understand why you're attacking the government's case and how far it goes, but I'm expecting sometime you'll tell us what your case is and what you say the criteria are, because we've got to try and find some test that is,
we do.
That can be applied.
Absolutely. I'm getting
there. It's quite hard to pin down any particular formulation, but we want to know what the rival one is.
Of course.
I mean, are you going as far as to saying that anything that affects the environment comes within the scope of our House?
No. Could I just address the final limb of my learned friend and the Court of Appeals approach, and then we'll get on to my one, but I entirely see that's really where the difficulty is. And one of the reasons why I've started with the domestic law is that we can get very far with the Vienna Convention materials, but fundamentally it's at a relatively high level, the articulation of that approach. Now, I say it's broad. I say everything supports me on that. I say it includes policies. I say everything supports me on that. My learned friend says the opposite. But it's really when one descends into the detail as a matter of national law.
As I understand, your submission so far, I mean, admittedly, it's sort of knocking copy, if I can describe it in that way. But you're focusing on how does our national law work, and that's relevant to know what is national law, because when you come on to Article 9.3, it refers to national law.
It refers to national law.
That's the logic of you starting here.
That's the logic of my starting here, and it allows us.
But I think we still do need to know the answer to my Lord's question, how you positively put your case.
No, absolutely. So the final limb of my learned friend's case is discretionary decision-making, if I put it that way. So one doesn't have a statutory obligation to do the relevant environmental thing, and there isn't something in a policy saying when you do X, always take the environment into account. So we're in, for example, Fewings 3 without the rationality overlay. You've just decided to take it into account as a relevant consideration and committed public law errors in doing so. Now, already, it has to be the case, of course, that one's in a statutory framework which permits the taking into account of the environment. But it's said against me, well, in that context, there's an insufficient connection between the constraining law, the public law principles, and the environment, because that connection only arises once the decision maker has chosen to go into that field, has chosen to take the environment into account. But I say if we take that approach, it knocks out of the scope of 9.3 an important limb of the national legal framework in relation to the environment.
I mean, I think it's tolerably clear what you're saying, that you say, well, it may be optional whether they go into this area or not, but they have chosen to go into that area, and then there are public law obligations which apply consequent upon that decision. They have to rationally and comply with general public law principles when doing that.
That's exactly so, my Lord.
Right.
And it's said against me that there's an insufficient connection in some sense there with the environment, but I say not so. One has the legal principles, they relate to the environment. Just because that only arose...
Well, in a sense, the relationship to the environment, I think, on your case, is through the optional choice of the decision maker to make the environment a relevant consideration because they've chosen that, and then they have to get their consideration of it right according to public law principles.
That's exactly.
So you need those two things together.
You need those two things.
But you
together.
say that's sufficient. They've chosen to make it a relevant consideration. If it's a relevant consideration, public law principles apply, and that is national law.
That's exactly so.
All right.
So then, turning to my construction, in the Court of Appeal judgment, I'll give paragraphs to that, but also in my learned friend's written case, there's a repeated mischaracterisation of my construction. So paragraph 91 of the Court of Appeal judgment characterises my case as being whether a contravention of any national law might have an impact on the environment or have some effect on the environment. 92 has an effect on the environment. 94, effect or affects the environment. 96, so long as it has an effect or impact. 134, vitiated by public law error in some way connected with or having an effect on the environment. And again, 135.
Right. So I think that's the submission you have made clear you're not making to us.
I'm not making that submission, absolutely. So what I'm excluding...
Can I just check, again, purely as a matter of historic record, was that a submission made to the Court of Appeal? Or
not by me, by the intervener.
Right, okay.
And there may have been... I don't think there was confusion about who was making which submission, and I think it was clear between us who was making which submission.
Yes.
That's never been my case. So what I'm excluding... My lady similar is...
Sorry.
No, it's okay. I had a hearing
What
in
you're
COVID in which I
excluding-
sank.
What you were excluding?
I think it is on page,
Sorry.
on page 174 in the Court of Appeals judgment. Well, you tell us if your submissions are inaccurately recorded, but it says in paragraph 71
Yes.
that WWF goes further by suggesting that it encompasses all national rules which have some bearing or are capable of producing some effect on the environment.
Exactly right.
Yeah.
Or which might affect the environment in some way, etc., etc.
Yeah.
Of course. So that was the distinction between us.
Yeah.
So I exclude what I would call incidental impact, collateral impact on the environment. Now, that sort of impact would arise very frequently because the environment being what it is, many decisions will have that kind of collateral impact on the environment. So I don't know if your lordship, your ladyship would be assisted by examples, but at the moment there's lots of tech litigation, as you'll know. When a regulator makes a request or imposes an obligation on a tech company, they need to do more things with the computers get hot, they need cooling.
Yeah. I'm not sure you need to belabor this point,
No,
because
but
it's
we
pretty
know-
obvious that...
It's a kind of floodgates point, is
Yeah.
that if it goes that far, then the scope is incredibly broad.
Yeah, absolutely.
But just so we're clear, I think your submission, as I'm understanding it, is specifically to make the ambit much more focused, because you say national law operates in a way which is much more focused on the environment, including in relation to Fewings 3 on the basis that we were just talking about. If the decision maker has specifically chosen the environment as a relevant consideration, well, that's immediately making national law more focused down on the environment.
It does, absolutely, my lord. So I think there are maybe two axes for the argument, and one is the type of law, the type of legal obligation, and that's something which I failed properly to convey, I think, to the Court of Appeal, because it's repeatedly said against me, this case is all about related to. But it's not all about related to. One of the most important features of the case is to resurrect the importance of Fewings 3 and policies and public law error as the types of law which form part of national law, which can relate to the environment. So
yeah. And just to add to that, and consultation. I mean, often consultation is a matter of choice.
Of course.
But you might have consultation about the environment,
yeah.
and then you have to get the consultation right if you've chosen to do it.
It's said now what's outside. But yeah, no, absolutely. So that's really a quality of law, a type of law point. That's really important. And in a sense, that's the focus of my submissions. But when we're thinking about what kind of connection could fall within relating to, so imagine we're looking at a policy, and rather than it saying you must take the environment into account, it says you have to take account of, I don't know, the size of boilers in school or something. And people are saying, gosh, size of boilers, that has got something to do with the environment, but not masses to do with it. Well, in that case, it's obviously going to be a judgment call for the judge reading the papers, but all of the materials, which we'll go through, push in favour of a looser connection, a broader relating to. But obviously, by its very nature, that's the sort of test that one determines by reference to the facts. So relating to can go broad, can encompass more than just saying climate change. But the true vice of the Court of Appeal's judgment, what it's doing, which is so dangerous, is carving out types of law, which on their face very clearly relate to the environment, however narrow relating is. So we have those two different axes, if I can put it that way, type of law and extent of relationship. And my formulation, set out at the end of my written case in paragraph 1, is that Article 9.3 should apply to all legal requirements with which the defendant public body needed to
just
comply.
slow down a little.
Yeah, sorry, you gave us a reference, I didn't note it.
So it's paragraph 1 of the end of my written case, where under the practice direction I summarise my case, my reasons.
Ah, right. Right, 84A, is that what you're looking at? Page 67?
Yes. It's the second sentence. It should be read as applying to all legal requirements with which the defendant public body needed to comply in order to make a lawful decision, where the requirements relate to the environment, with relate having a broad rather than a narrow meaning.
But you're still using relate there in a narrower sense than effects.
It's narrower than effects. It's narrower than collateral impact. And often it will be pretty obvious on the face of the document that it maybe not just 9 times out of 10, 99 times out of 100, the connection with the environment will be stark. But still, when one has a case...
Well, is it right to say that relate is directing one to the subject matter of the legal requirement and not to its impact? And that seems to me to be a key distinction. Otherwise, I'm not quite sure what different shades of meaning there are.
So...
Maybe there's some other possibility. It doesn't, not terribly helpful to say broad rather than narrow, because we want something a bit more tangible than that.
So the difficulty is that the Court of Appeal approached that question by essentially narrowing the type of law which counted and looking for purpose, and in particular parliamentary purpose. And that was one of the causes of the fundamental error, essentially.
I understand your case about that.
Yeah, and that's your first axis, but I think we're asking for assistance with your second axis.
It may be that relating to could have, rather than a purpose test, a function test. So the function of the obligation relates to the environment. So that may help us if we're trying to distinguish between collateral impact, so accidental impact, arbitrary impact. It's got nothing to do with the legal regime.
So the obligation imposed by the national provision, is that what you're saying? What obligation?
The legal requirements. Yeah, the legal requirements. So they could be in the statute, in the policy, the public law requirements when you're taking that decision-making. They have to have a sufficient connection with the environment.
So if you look at the way Friends of the Environmental Laws Foundation, page 1, 2, 4, paragraph 18. Do you agree with that? you're saying.
Yeah. I think what's being put to me, my lord, is, I may be misunderstanding, but not just that point, but how close is sufficiently close?
Yes. That seems to be quite a question-begging formulation. I mean, how does one approach the question, is there a sufficiently close link? Do you look to the purpose? Do you look to effects? Because I mean, that formulation doesn't exclude the case that you have eschewed, which is it's not concerned just with the effects. So I think we're asking for assistance with how exactly you formulate positively your case about what one looks for as a judge applying the relates to the environment test.
So it may well be that often something like the purpose test, which was formulated by the Court of Appeal, but provided it can attach not just to Parliament,
Yes.
but to the purpose of the policy.
Yes.
And the
Function and purpose seem quite similar to me.
They're relatively similar, aren't they? Save that purpose can have the idea of, the watchmaker, have the idea of a mind behind it, and function can be something one observes happening, perhaps. So maybe it's a mix of the two.
Right. So if we take a Fewings 3 type situation, I think you're now saying if the decision maker, as a matter of choice available to them because it's a Fewings 3 type situation, says, well, let's take a case, I will treat it as relevant, the impact on the environment as a relevant consideration, then it's the choice by the decision maker in that situation that has, if you like, chosen as a purpose of that relevant consideration, protection of the environment.
Yeah.
But that's quite narrow, because you're not looking for parliamentary purpose directly, you're looking for parliamentary purpose as supplemented by the purpose of the decision maker in choosing what consideration to treat as relevant. Is that how you're putting your case, or do you want to go wider than that?
I go wider than that, but
right,
I
so
don't...
formulate it, please.
I go wider than that, but I'm mindful of this, that in many cases, in my submission, the reality will be that the decision maker would say, I've taken climate change into account, I've taken greenhouse gases into account. So actually, of course, it's very important that we have this discussion, but although it sounds narrow, I think once we've got that elective decision making pulled into the scope of 9.3, that will actually help in many, many cases.
No, I follow all of that, but in a sense, you've just said on this approach, there are lots of easy cases, because the decision maker will often say, taking under climate change and so on. So those are all, on this argument, easy cases.
Yeah.
I think we're asking for assistance with how one would approach a more marginal or difficult case.
Well, I think then one could look at, say, the size of boilers in schools and say, why would that be of interest? What's the proper way of characterising the function of that part of that consideration? And if one can form the view that there's a relationship between that and the environment, the role it plays, then that could indicate it falls within 9.3, rather than it serve a different purpose in the decision-making.
How is that different from a purpose test? I mean,
seems to me it's saying is one of the purposes, at least, of the provision to protect the environment.
Or is one of the roles it served, I suppose. So it didn't have to be in the mind of the decision maker.
No, well, nothing has to be in the mind of the decision maker, probably. So, objective analysis.
It's an objective analysis. That's entirely right.
I mean, people don't usually pluck these things out of the air randomly.
No, they don't. And I realise that I'm doing a poor job of explaining to your lordship, your ladyship, where I see the line. But it is this difference between something which is collateral, as in it's arbitrary. The decision maker wasn't interested in the environmental nature of the consideration or of the impact. And then considerations where even if it doesn't have environment printed on its head, the decision maker is interested in and would view as legitimate the fact that it has that connection with the environment.
I mean, all that way of putting it seems to me to be consistent with saying you are looking at the purpose of introducing this in a Fewings 3 type situation as a relevant consideration.
But what's important...
But you seem not to like a formulation based on purpose, but what you've just given us wasn't really a formulation and seemed to devolve back to purpose.
I see that, my lord, but what concerns me is if we say purpose, if your lordship, your ladyship were to say purpose, that can be viewed quite narrowly when it's being applied to these cases at the pleading stage. And what I'm anxious to preserve is the full scope of 9.3.
But if, as you said earlier, the provision encompasses policies and public law considerations, including viewings 3. Doesn't that deal with your anxiety?
It deals with much of my anxiety, that's right. But
so if you could just give us the formulation that we can write down that you say is the test that deals with the rest of your anxiety. Sorry to press you on this.
No, it's, of course. So the rest of my anxiety is that there may be...
I follow the background anxiety that purpose may be too narrow. Give us the formulation which isn't purpose.
May I suggest this? May I suggest any relationship with the environment other than one which is collateral or incidental?
But what counts as collateral and incidental? How do you tell that other than by looking at the purpose of introducing the consideration? What makes it collateral? It's collateral to what? It's collateral to the purpose. It would be the way I would normally think of addressing that sort of question.
I see if purpose entirely occupies the field of everything in relation to which there's any degree of intentionality, then maybe the reason I'm doing such a poor job of answering your Lordship's question is that purpose does everything we need it to do.
Well, that's...
Well, the other, I suppose another approach would be to say that you distinguish between indirect and direct and indirect impacts if you're going to go down the causal route. But I don't think you are going down the causal route.
I like a degree of passive observation of the function or the role of the connection, and that's what I think is missing, but I'm doing a terrible job of articulating, I see.
All right, well, let's not take up more time now, but we will need your assistance as to what formulation you positively are offering us on that.
And relating to.
Yeah.
Yeah.
I mean, and just so you know, I mean, courts come across problems of tests of things being collateral or direct or indirect in all sorts of contexts. And I mean, certainly in my mind, the usual ways in which you address that are either purpose, you say it's collateral to the purpose, or causative, as my Lord says. You say it's just not caused by, there isn't a causal connection.
Or the connection is too remote, or it's indirect, or something like that.
But at the moment, you seem unhappy with purpose. You don't seem to be positively adopting a causal test. So, shall we leave it there?
Let's leave it there, and I'll come back.
You come back.
Sorry
yeah,
to
but
not
you will
have been
need
of
to
more
do that.
assistance with that. So that brings to an end my going through the application of the principles to domestic law, not having gone to my case yet. I'm mindful of time, so I'm now going to go through things at a bit of a trot, but equally not too quickly, because I know then that defeats the purpose of doing anything at all. So just for your Lordship's notes in general, before I get into the Vienna Convention, we know why we're talking about the Vienna Convention, because the CPR says if you're in 9.3, you're in...
Yeah, it directly adopts the international obligation, so
it
in
does.
a sense it's made it part of domestic law.
Absolutely so, and that's the approach I'm taking. I'm mindful that that is not the approach taken in Scotland. So we've got the rules of the Court of Session at page 972. Given you the wrong reference, I'm afraid. Here we go. 963.
Sorry, 963.
Now, my understanding, though I'll be corrected, is that in its application, it's treated as if 9.3 were the test. But just so you have it, it's Rule 58A.1, subparagraph 1C, relevant proceedings which include a challenge to an act or omission on the grounds that it contravenes the law relating to the environment. So rather than refer to 9.3, it puts the words directly in the rules, but it also omits the words provisions. So we don't have provisions of the law relating to the environment, we just have the law relating to the environment. And on occasion, it's been said against me, well, the word provisions are very important.
Right. Can you help? Why are we looking at this provision? It's a different statutory provision. There may be all sorts of arguments that the that arise on it, which don't seem to be before us. Why are you taking us to it?
I'm taking us there simply, my Lord, because as the Apex Court for Scotland as well, interpreting a treaty which applies to the UK, I wondered if your Lordship, your Ladyship may be interested in the Scots position. If not, I'll carry on.
All right.
Turning to the Convention, construing it in accordance with Articles 31, 32 of the Vienna Convention, with which we're all very familiar. Of course, we've got the recent judgments in JTI Polska and in infrastructure. I'm going to start by addressing some features of the Convention itself, and then quickly go on to some of the cases. So 4 points I'd make in relation to the Convention. The first concerns its purpose. So I say that it's got the overarching purpose of promoting and facilitating environmental protection, so increasing or strengthening that protection. And that means that its provision should be construed with those gravitational pulls in mind. And you'll have seen from my case, I rely in particular on the recitals. The recitals are at page 4006 in the bundles, affirming the need to protect, preserve, and improve the state of the environment and to ensure sustainable and environmentally sound development, recognising that adequate protection of the environment is essential to human well-being, and so on, and considering that being able to assert the right of adequate environmental protection, citizens must have access to not only information, but access to
Where do we have
justice.
the convention?
4006.
Thank you.
4006, thank you, my lady. And we read through those recitals, and then we have the objective in Article 1.
Page?
If I just go back a page, sorry, I've been so bad with my page references. So the objective is 4008.
Yep.
The recital is 4006, and the ones which I particularly draw your Lordship's, your Ladyship's attention to are from affirming the need to protect, preserve, and improve the state of the environment, down to considering that to be able to assert this right. So those four.
Sorry. So this is on 4006, is it?
Yes, it is.
And which, you said affirming.
Affirming the need to protect,
recognising
preserve,
adequate protection, recognising every person has the right, and considering that. Those four?
those four in particular.
Right.
And then over the page, 4007, by the second hole punch for me, concerned that effective judicial mechanisms should be accessible to the public, including organisations, so that its legitimate interests are protected and the law is enforced.
Well, don't you also potentially get assistance from the 1-3 down on that page, recognising the importance of respective roles individual citizens, non-governmental organisations and the private sector can play in environmental protection?
I do, thank you.
You need that one as well. Okay.
Then we have the objective on the next page. In order to contribute to the protection of the right of every person, of present and future generations, to live in an environment adequate to his or her health and well-being, each party shall guarantee the rights of access to information, public participation in decision-making, and access to justice in environmental matters in accordance with the provisions of this convention. And I'm going to go on to Brown Bear and the other cases in relation to the purpose of 9.3, which I say is ensuring environmental protection. But just when we're thinking about purpose, and for your note, of course, in the well-known Edwards line of cases, Lord Carnworth, in paragraph 26, it's page 1545, I'm not going to go to it, picked up the language of Advocate General Cocotte in that case. The environment cannot defend itself before a court, but needs to be represented. This is something that's been repeated throughout the judicial system, most recently the Badger Trust case, Mr. Justice Fordham. Members of the public and associations are naturally required to play an active role in defending the environment. Something bigger than all of us is at stake. So that's at page 2489 of the bundle. And of course, as we know recently, the Strasbourg case in the Verein Klima Seniorinnen has had cause to remark that the particular features of climate change speak in favour of recognising standing to NGOs in that particular instance.
What was that reference page?
That is paragraph 499,
Yep.
but I will ask my learned friend to get the reference to the Klima Seniorinnen case. So I say this is an obvious, significant, purposive, gravitational pull.
And the Klima Seniorinnen case, that's not talking about the Aarhus Convention, but you're just making a general point.
Making a general point about the importance of NGOs, members of the public, bringing cases in relation to the environment.
Yes.
So my learned friends make 3 points in this regard, paragraphs 38 to 40 of their written case, page 84. So they rely on the provision of Article 3.5 of the Convention. If you go to 4010 in the bundle that we've just had open in the body of the Convention, we're in general provisions. And we see, one, the obligation to take the relevant measures to put the Convention into effect. And subparagraphs 2 to 4, essentially again are promoting or furthering environmental protection. And then 5, which is the one that's relied on against me, the provisions of this Convention shall not affect the right of a party to maintain or introduce measures providing for broader access to information, more extensive public participation and wider access to justice in environmental matters than required by the Convention. So that's right. It shows that there may be something.
Just saying it's a floor, not a ceiling. So
Absolutely, that's all it's saying. That's all it's saying. And it's obvious that Article 9.3 doesn't entirely fulfil the total possible world of things one could do in relation to environmental litigation. Not least it excludes criminal matters. So that's a bad point. The second point they make is that vague appeals to broadness can't help. They refer to a Bayes case, which I'll come to in due course, that doesn't say that. But in fact, of course, when we're thinking about purpose, we're in a Vienna Convention situation. You're about to perform your single and combined operation, and you take purpose into account. It's not a vague appeal to purpose. It's a core part of your decision-making and your construction. And then the third point they make is that ensuring environmental protection, they say, is one of Article 9.3's purposes only when it applies. So this posits a view of the world in which your lordships, your ladyship, identify the purpose of a provision, disregard it for scope of application, and revivify it only for purpose of operating within the preordained and predistinguished scope of application. Again, it's a very bad point. So that's purpose. The second point to bring from the Convention is the meaning of provisions of national law. So the Convention obviously is written so that it can apply across 48 state signatories. It uses the word legislation repeatedly, as set out in paragraph 30 of my written case. Articles 2.3b, 2.4, 3.1, 4.1, 5.2, 5.5, 5.5a, 6.6f, 9.1, 9.2. We see legislation, comes through all the time. If you mean legislation, you say legislation. It doesn't say legislation here. It uses policies, plans, programmes, executive regulations, again set out in paragraph 30 of my written case. Article 2.3b, 5.3c, 5.5a, 7, 8, 10, 2a. So it uses that specific language if it wants to. Importantly, it extends to those things. It imposes requirements in relation to policies and programmes and plans. Unsurprisingly, because it is to be expected that that is where one finds environmental obligations. And then fourthly...
Sorry, where does this impose obligations in respect to policies, programmes and plans?
So to give you an example... So if we go to Article 5, collection and dissemination of environmental information, and then we look at sub 3, this is on page 4014. Each party shall ensure the environmental information progressively becomes available, and then the examples given are A, reports on the state of the environment, B, text of legislation on or relating to the environment, C, as appropriate, policies, plans and programmes on or relating to the environment and environmental agreements.
Yeah, I mean, strictly that's about giving access to environmental information, which is another part of the convention.
It is. So what we're doing now is the context part of Article 3.1.
But why does the context of a provision that's dealing with access to environmental information help us with the meaning of Article 9.3?
So the fact that one finds policies and plans emerging in each of the other pillars of the Convention shows that they're assumed to form part of the corpus of environmental rules. We see that if we go to Article 7 as well, we see public participation regarding plans, programmes and policies relating to the environment. And so the drafters, I suppose 2 points here, the drafters use the language legislation and use the language policies and also use the language law. That's my main point. But a subsidiary point is that plainly it's anticipated that policies can contain important things. I put it no higher than that. That obviously is the position. It's not surprising.
Right.
In terms...
The provisions of national law, doesn't that require us to connect it ultimately with a legal obligation that's to be found somewhere, wherever it's to be found?
It does, my lord. If we go to 9.3, which is on page 4020, this, of course, being the core provision for our purposes. In addition, and without prejudice to the review procedures referred to in paragraphs 1 and 2 above, each party shall ensure that, where they meet the criteria, if any, laid down in its national law, members of the public have access to administrative or judicial procedures to challenge acts and omissions by private persons and public authorities which contravene provisions of its national law relating to the environment. So that's right, my lord. Provisions of its national law relating to the environment means, I say, requirements of the national law relating to the environment. Provisions plainly can't mean written parts of statute, because we know it's common law, we know it goes broader than that. That's a poor argument. And I also rely on the appearance of the words national law earlier on in that same article in 9.3, and that is where they meet the criteria, if any, laid down in national law. And that is understood and applied in these courts as encompassing the full range of criteria laid down by national law. So not just what one might find in statute, also in the CPR, but also, of course, judge-made rules. And I included in my written case a reference to duty of candour, for example, and a breach of duty of candour on the claimant's side being a reason for refusing permission. So it's the full gamut of national legal requirements. And before we leave the...
I mean, if I may say so, I understood my Lord's question really to be taking issue with your point on Articles 5 and 7, because you could have a regime where there's national law on one side and a whole raft of policies which just don't have any connection with national law.
Yeah.
And you'd still have an obligation on the state to give access to information about those policies.
And you're entirely right. I'm sorry.
And so, well, certainly for my part, I was trying to see how you get assistance from the mere fact that the Convention also refers to policies with your interpretation of Article 9.3.
I see that, and I may have put it too high. There are, of course, policies or things like policies which can be entirely internal and don't generate obligations vis-a-vis the claimant in any particular case. Some of them will give rise to obligations on the decision maker, some of them will be justiciable, slightly the wrong language, but your
real point, is this right? I don't want to misrepresent you, is that provisions of national law shouldn't be interpreted to tell you anything about the particular source of the obligation, the source can be in anything. It could be in a legislation, judge-made law, or a policy, but you've got to identify a legal obligation that's contravened.
Absolutely. It's exactly that, my lord. And more importantly, perhaps, well, not more importantly, but one other way of putting it in relation to the case against me is it definitely doesn't mean legislation. And then just in terms of the word relating to, before I leave the convention.
Which point are we on now? Your 4 points, which one are we on now?
Because I took 9.3 earlier, we're now on the last of the 4 points. So I've taken them slightly out of order. So it's purpose, national law. I was going to do relating to and then 9.3, but I've just addressed 9.3, so I'll come to relating to before I leave the convention. And in relation to relating to, it's a short point. In the convention, sometimes we see that impact or effect is used as the trigger for a certain obligation. Classically, where it's a particular project, for example, and that would be so in Article 6, for Article 6 purposes, so it would be a sensible test in those circumstances. But we do see, and I take this, in Article 2, I think, an effects test is used in relation to legislation, plans and programmes. So we're in Article 2, sub 3, sub B, the famously broad definition of environmental information, and includes information on, and includes their policies, legislation, plans and programmes affecting or likely to affect. So that language is used there and is not used in 9.3, and I take that. Equally, in the provision in Article 5, which I just took your lordships to and your ladyship to, the language is used of on or relating to. And indeed the word on we see here at the beginning of the listing of information. And on, I say, is a tighter connection. So effects may be looser and on is tighter, and we have relating to in the middle. That's all I wanted to say about the convention. So turning to the main cases which are considered by the Court of Appeal in their judgment. I've been given the reference for the Hein case. It's page 3176 for paragraph 499.
Thank you.
So if we just open the judgment of the Court of Appeal at page 175, and we see in paragraph 78 to 81, the heading is the purpose of Article 9.3, and 5 cases are considered in that section. So the Brown Bear case, then Deutsche Umwelthilfe, Austin, and the FCA case. And the reason why this is so important is it's really the origin of the Court of Appeal's view that only provisions which have the purpose of protecting the environment fall within Article 9.3. So although the heading is what's the purpose of 9.3, what we see coming through these paragraphs, for large part, is only provisions of national law which have an environmental purpose fall within 9.3. And we know, because I've now said it enough times, that by purpose they mean parliamentary purpose. So this is really where the error begins, if I can put it that way. So the Brown Bear case is at tab 118 in bundle 6, page 2682. So just by way of background, obviously this is an EU case. EU law comes into this appeal in two ways. Firstly, some of our domestic cases obviously relied on EU law or had an EU law element back when we were members of the EU, and so it comes in via that route. And Brown Bear has that sort of life. But secondly, of course, there's a general principle of treaty interpretation that we interpret consistently across contracting members if we can, so they're relevant under that heading as well.
Am I right, the EU is itself a party to the Aarhus Convention?
It is, and it's mildly...
Oddly, but it is.
Yeah, it is. So it's mildly complicated. It is a party to Aarhus. 9.1, 9.2 were incorporated via directives. 9.3 hasn't been incorporated. So 9.3 is implemented domestically vis-à-vis EU institutions. And we see that in some of the cases. But in terms of the member states, there is no EU implementation of 9.3. So if we start in paragraph 2, page 2705, paragraph 2 explains that the context of this case is a Slovak NGO which wished to be a party to administrative law proceedings relating to the grant of derogations to the system of protection of animals, including the brown bear. And if we flip over to paragraph 45, so it's on page 2713, the Court of Justice, I think the Grand Chamber, first of all holds that 9.3 does not have direct effect. And this is the important paragraph 46 when we're construing Article 9.3. However, it must be observed that those provisions, now the words those provisions refer back to paragraph 45. It must be held that the provisions of Article 9.3. So it must be observed that those provisions, although drafted in broad terms, are intended to ensure effective environmental protection. So that's the central paragraph when we're thinking about the purpose of 9.3. What the Court of Justice then did is hold in 47 and 48 that due to the absence of EU rules governing the matter, it was for national procedural law, as we know, to ensure that the rights which derived from EU law, in that case the Habitats Directive, were effectively protected, in particular by observing the principles of equivalence and effectiveness. And then in 49 and 50, it concludes that in order not to undermine that effective protection, the National Court must interpret its national law in a way which, to the fullest extent possible, is consistent with the objectives laid down in Article 9.3 of the Aarhus Convention. And we know what those objectives are because they've told us in paragraph 46. They're of ensuring effective environmental protection. Now, the Court of Appeal, in the present case, paragraph 78 and 79 of its judgment, it focuses on the fact that the Brown Bear case related to the Habitats Directive, which it said was plainly for the protection of the environment. Now, that's right, but it's not relevant to the general articulation of purpose. And the Court of Appeal then, in paragraph 79 of its judgment, refers to the CJEU's explanation in the Brown Bear case that Article 9.3 applies to contraventions of national legal provisions which are for the protection of the environment. The Court of Justice does not say that. It's just not there. It's not in the judgment. Now, my learned friend, in paragraphs 59 to 60 of his written case...
Well, they do refer, don't they, to provisions that are intended to protect the environment.
When describing the EU law rights, that's right, and that's how the obligation, via the principles of effectiveness and equivalence, come into play. But the Court of Justice doesn't, and nor would it have, because it wasn't an issue in the case, but the Court of Justice doesn't say the purpose of Article 9.3 is to ensure effective environmental protection, and that means that only laws which have that same purpose can fall within its scope.
No, right.
I mean,
what they seem to be doing is in 46, they're making an observation about the effect of Article 9.3, but it doesn't actually drive their reasoning, because what then follows is they refer to ordinary EU rules about effectiveness of procedures to safeguard rights which are in EU legislation.
That's exactly so. So the two come together, and they need 9.3, I think, to offer some of the extra Aarhus protection that comes with it, and that's how it all comes together. But you're right, my lord, that principally that's an EU law waiver, effectiveness equivalence, carve out from national procedural autonomy kind of case. But the general articulation of principle we have there for 9.3, and we also don't have the core thing, which is an answer to the question, what kinds of provisions of national law fall within it? That's just not there. So I'm going to quickly go to Venn next, even though we've spoken about it a little already. Page 1629. So in the Court of Appeal's judgment, in these paragraphs, they summarise then as adopting the CJU's explanation in the Brown Bear case that Article 9.3 applies to contraventions of national legal provisions which are for the protection of the environment. They've said that that's not an accurate summary of Brown Bear, but it also fails to capture Lord Justice Sullivan's reasoning in Venn. So if we look at 1631, the context is an application under Section 288 of the Town and Country Planning Act to quash a decision of an inspector appointed by the Secretary of State, allowing an appeal against a refusal to grant planning permission. Para 2, ground 1 was that the inspector had failed to have regard to emerging local plan policy in the form of the Development Management Local Plan Policy, said to be supported by paragraph 53 of the MPPF, which we've spoken about, and also by other policies. Issue 1 is above paragraph 10, that's on page 1633. So we have the description of environmental information in paragraph 10.
Sorry, just on 2. So there are 2 things. It's fail to have regard to an emerging local plan policy. So it's not actually yet a plan.
It's not a plan yet, exactly.
But they also refer to the MPPF as well. They say there's a policy.
The MPPF required you to have regard to emerging policy. So it was a breach of the MPPF, arguably, not to have regard to the emerging plan. But this is a Section 72C case, so material considerations on a so obviously material basis. So it's Fewings 3.
Right, so that is the nature of the case.
That's the nature of the case. And we see that the Court of Appeal characterise it as Fewings 3, I think. I'll ask for the reference.
But a subcategory of the Fewings 3 where it's obviously material.
Because the argument is that they didn't, exactly. So the JR is you didn't have regard to the plan, and you should have.
To the emerging plan.
The emerging plan, I'm sorry,
right.
To the emerging plan. And so the way that could be given legal teeth is by what we now view as Fewings 3, so obviously material.
All right, thank you.
Paragraph 10, this deals with the broad definition of environmental. Paragraph 11, my learned friend Sir James accepted that meant that it would catch most, if not all, planning matters.
Here we're talking about the meaning of environmental information.
Absolutely, absolutely, my lord. Then we see the reference to Brown Bear, so the long Slovakian name, it's the Brown Bear case. Then in 12, we see that Lord Justice Sullivan picks up paragraph 46 of that judgment, it must be observed that these provisions, although drafted in broad terms, are intended to ensure effective environmental protection. And then we see 49 and 50, which we've just looked at, applying essentially EU law, remedial law, but also by reference to being consistent with the objective laid down in Article 9.3 of the Convention. Then in paragraph 14, we see that Sir James ran what I might style as a version of the argument which he is running today. So essentially he says that the relevant statutory provision, section 72 of the 1990 Act, which required that the consideration be taken into account via viewings 3, did not relate to the environment, but the emerging plan did relate to the environment, but there was a gap between the two. So neither one possessed the two requisite things, being both law and relating to the environment. So the claim failed for Aarhus purposes. And here we get to the paragraphs which I summarised on my feet earlier. So in paragraph 15, we see the learned judge summarise the importance of the town and country planning system and gives the examples of the environmental impact assessments and obligations imposed by the Planning and Compulsory Purchase Act. Neither of them an issue in this case. So he's just thinking, let me consider the planning regime at large. Then we have in 16, it's characteristic of the UK's approach to environmental protection that much, if not most, of the detail is contained not in statutory regulations, but in policies. So this is looking with pragmatism and realism at where those requirements are actually to be found. And then in 17, essentially, given the reality of how that framework is put together domestically, that combination of statute and policy, that it would deprive Article 9.3 of much of its effect if a distinction was drawn between policies and statute. And he refers back to the Brown Bear case in reaching that conclusion. So we have the importance of the purpose of Article 9.3 helping us when we're determining the provisions of national law which fall within it. And in that case, the whole of the national legal framework, the statutes and the policies which speak to one another, including via, so obviously material, picked up and put in provisions of national law relating to the environment. The next case considered by the Court of Appeal, I'm not going to take you to, but if I summarise my position on it, it's the Deutsche Umwelthilfe case, which is at page 2916 of the bundle. So this is a decision in which the Grand Chamber, post-IP completion day, held that the fact that a provision possessed an environmental objective meant that it fell within Article 9.3. So that was relying on previous judgments in relation to the relevant provision. It's a defeat device provision in the context of the Dieselgate kind of context. Various cases before had needed to determine as a matter of statutory construction what's the objective of the provision. They've said environmental protection. The Grand Chamber said, oh, right, so it's in Aarhus. But it didn't say that that's a threshold requirement. That's obvious on the face of the judgment, but it's particularly obvious from the fact that the Grand Chamber cross-checks its conclusions with the implementation guide. And the implementation guide uses the formula, the decisive issue is whether the provision in question somehow relates to the environment.
What's the paragraph reference for that?
(55 to 56).
Thank you.
And it's paragraphs 51 to 56 that your Lordship needs to read to see all of that. But 55 to 56 are the implementation guide. Austin, again, I won't take you there, if you'll forgive me, given time.
I'm so sorry. What was the page reference for the Deutsche Bank case?
2916.
Thank you. Thank you.
Those paragraphs, if you wanted, that was 2949.
2949, thank you.
That's the start of the case.
Thank you.
Thank you very much.
So we have Austin. This is Court of Appeal in Austin, page 1612. And to summarise that judgment with which you'll be familiar, the Court of Appeal, in that case considering private nuisance, first of all in paragraph 17, emphasised the importance of access to justice and the function of litigation in environmental protection. And then in paragraph 22 of its judgment, held that private nuisance claims can fall within Article 9.3 if they meet two criteria. The first is that the nature of the complaint must have a close link with the particular environmental matters raised by the Convention, even though the action in nuisance does not directly raise them. And the second is that the claim must, if successful, confer significant public benefit. In paragraph 81 of the judgment of the Court of Appeal in this case, the present case, the Court of Appeal referred to Austin as support for the proposition that in order to fall within Article 9.3, the subject of a legal provision must be environmental, or its purpose must be to protect or otherwise regulate the environment. I say Austin is not support for that approach. If anything, it supports a broader approach in which there's no need for the action in private nuisance directly to raise the environmental matters. And the focus is on the test of the actual complaint having the link to the environmental matters in a passive or observable sense, rather than a test of purpose in the abstract, which is, of course, what we were talking about earlier this morning.
I have some difficulty with Austin because the purpose of private nuisance, as I see it, is to protect people's enjoyment of their property. Any environmental benefits are incidental to that or collateral. It might be different if you were bringing a private law claim in public nuisance, where you are concerned about harm to the public.
And
I don't think it matters for your case, but I'm just indicating that insofar as you're relying on Austin, I have doubts about it.
So, my Lord, I'm relying only on the misinterpretation of Austin by the Court of Appeal. I'm not placing positive reliance on it. I know that Austin is something which I think neither of us are going to venture into the rightness or wrongness of in the Court of Appeal and the ACCC, not least because it's in many senses live. I think there's a consultation ongoing at the moment about application of Aarhus to private claims, and neither of us are in a position to address that very satisfactorily. But I do say that the Court of Appeal below, placing reliance on Austin in the way it did, just mischaracterised it. It's not what the Court of Appeal said. Then finally, in that run of cases, in those paragraphs that I took you to, the Court of Appeal concludes with the decision of Mrs. Justice Beverly Lang in the FCA case. And that is the first and the sole time you do see a judge articulate the approach endorsed by the Court of Appeal, at least in a headline sense. And so in that case, Mrs. Justice Lang did formulate a test of subject or purpose. That was in connection to...
Sorry, could we have a bundle reference? So
of course, sorry. Page 2439.
Thank you.
So that's a judicial review, you see in paragraph 9, concerning whether the FCA had erred in deciding that it was satisfied that a share prospectus contained the information required by Article 6, sub 1, and Article 16 of the prospectus regulation. And the learned judge held that the legal regime in question didn't have as its object or purpose environmental protection, and that was one of the reasons, the main reason, why she said it fell outside Article 9.3. She then tested it by reference to other things like environmental and benefit and so on, but that was the main reason. So I do say that that test is wrong, at least if I'm right to have my concerns about the word purpose, but more importantly, wrong if the intention is to lock us down to express statutory provisions or a virus which has that discernible purpose by having on its face the big stampy word environment. I do say that's wrong. It may not necessarily follow, but this depends on where we draw the peripheral line. It may not necessarily follow that in substance her decision was wrong. And it may be, if this falls the wrong side of our incidentality or collateral test, then it was rightly excluded from 9.3. It may not matter massively, but the way that that would work is that the public law decision in the FCA case was at one step removed from the environmental matters. So what the FCA does when it's controlling share prospectuses is determine whether the issuer has correctly assessed materiality. That's what it does. So it's not the same as the public law decision maker itself identifying what it perceives to be material in an exercise of Fewings 3. So I can live with the outcome in the FCA case, although I say with respect that the judge applied the wrong test. And that is the only articulation of the test that you'll find in those cases that supports the Court of Appeal. Otherwise, those paragraphs are wrong. If I move now, since I'm in the cases, just to answer or summarise for your lordships and your ladyship my approach to the other cases which feature in the Court of Appeal judgment. The first is the case which is referred to as the DBEIS case, DBEIS case. It's at page 1934 in the bundle, and this is referred to in paragraph 90.
I'm sorry, I missed the reference. What was
1932.
Thank you.
And the Court of Appeal referred to this case as establishing that a broad purposive approach to the meaning of the Aarhus Convention must not be taken too far. I say that's wrong. That's not what the case stands for at all. That is a case in relation to access to environmental information where the entitlement on the face of the convention could be extremely broad, and in fact a purposive approach is relied on in that case as the driving motor to say, well, it has to be information that could be of some use to you. You can't just ask for anything at all. So it's a case which supports the importance of purpose rather than reduces it.
Which paragraph are you referring to for that?
So if we look paragraphs 45, 47, 48 and 54 of the judgment.
Thank you.
So the EIB case, so this is another EU post-IP completion date case, and this supports my submission that policies which are voluntarily adopted and constrain decision-making in the conventional ways that policies do form part of environmental law. So in that case, the EIB had to follow the Statement of Environmental and Social Principles and Standards of 2009 and the Climate Strategy. Those are defined in paragraph 23 of the Court of Justice's judgment.
Page, please.
2987.
Thank you.
And the Court of Justice held that those policies circumscribe the EIB's lending because they cannot be departed from without justification. This is in paragraph 88. The EIB cannot, without justification, depart from the environmental criteria relating to the eligibility projects for financing which flow from the Statement of 2009 and the Climate Strategy, which the EIB has imposed on itself to follow in its lending activity under pain of being found, as the case may be, to be in breach of the general principles of law, such as equal treatment or the protection of legitimate expectations. Paragraph 89, those documents circumscribe the EIB's activity. They form part of environmental law, so that supports my approach to the inclusion of policies. And then finally, we have the Mozambique case, the judgment of Mrs. Justice Thornton, overruled by the Court of Appeal in my case, or Court of Appeal indicated it was wrongly decided. Perhaps if we go there, 2155. Paragraph 1 this concerns a judicial review claim in relation to the defendant's decision to provide up to $1.15 billion export finance for the development of offshore deepwater gas production facilities in North Mozambique, made an exercise of a power under the Export and Investment Guarantees Act, 1991. And we see Aarhus cost protection after the words later in paragraph 9. In paragraph 10, her ladyship considers then. In paragraph 11, while the legal structure in the present case is obviously different, in my view, the broad point of principle in Lord Justice Sullivan's analysis in then, that environmental protection may be addressed in different ways in national legislation applies here. So the first defendant has a broad statutory power under the Act to make funding decisions. His power is exercised through the UK Export Finance. Section 13 provides for the Advisory Council, the function of which is to advise the Secretary of State. It was specifically requested to provide specialised advice. Then before providing funding, UK Export Finance assessed the risks and impacts by way of those two reviews, and it also has a policy on environmental due diligence and monitoring, which states it will take account of relevant government policies and will comply with relevant international agreements. And in paragraph 12, her ladyship says that to draw a distinction between the Act and the arrangements in place for funding would be, as in then, to deprive Article 9.3 of much of its broad effect, and refers in that regard to the case which we've just looked at, the EIB case.
I'm not sure this case is of much consequence as an authority, because it's just giving permission to apply for judicial review on an temporary judgment.
I see that, my lord. And maybe it's of more interest as a way of testing quite how the Court of Appeal sees the line is drawn. I should say that they endorsed, the Court of Appeal said that the EIB case was correctly decided because the Court of Appeal said EIB is like then. So we have that in paragraph 30 of the judgment. They both involved a legal requirement when reaching a decision to apply either a policy or an eligibility rule, the purpose of which was to protect the environment. My learned friend doesn't try and say that EIB is consistent with the Court of Appeal's judgment. Instead, my learned friend says that EIB is wrong and conflates law with policy. But the Court of Appeal says, well, EIB is the right side of the Venn line, but Mozambique is the wrong side of the Venn line. So we see here how complicated the picture is. So drawing those together then, the EIB and the Friends of the Earth case support my approach. I say namely that constraining legal requirements, including those which exist due to a policy or due to other aspects of the legal framework, whether electively ventured into or not, fall within 9.3. Now, my learned friend in his written case referred to some Irish cases, which I'll address relatively quickly. 2 points to make in this connection. They refer to a case called Conway. This is in paragraphs 58, 3 and 4 of their written case. Conway's in the bundle at 3251. I don't need to go there, I think, because it's common ground that mere ancillary impact is not enough. Though, of course, I need to come back this afternoon and explain exactly what I mean by that. But in that case, the Supreme Court held that just because all roadways have an impact on the environment, that's not enough to mean that all legislation connected with roads would be in the scope of Article 9.3. I think we all agree that that must be right. It doesn't help us massively in draw exactly where we draw the line. There's also the Heather Hill case, which is at page 3259 of the bundle, and my learned friend refers to that again in paragraph 58, but also in paragraph 95 of his written case. So the first way in which it's relied upon is essentially that it picks up and endorses the Conway approach to incidental impact not being enough. That's fine. The second way it's relied on is in relation to the attempt to carve out of the national legal framework public law principles. And it works in this way. So if I summarise the judgment of the Supreme Court in Conway, paragraphs 178 onwards, the Court of Appeal in that case held that the grounds of challenge were not within Article 9.3.
Sorry, 178 to which authority?
Heather Hill.
What are we looking
Heather
at?
Hill.
Heather Hill.
And
So
which page?
Where is Heather Hill?
So Heather Hill is at page 3295,
But the paragraph you're referring
and
to.
the paragraph I am looking at is 178, which I need to get up, unless I still have it. So I think it's page 3368 from my more detailed notes.
Yeah.
And
Is that right?
so in that case,
Bottom of that page, 178. Is that where you're...
that's where I am
Going.
exactly, if I just get it up myself. So what we see is that the Court of Appeal had held that the grounds of challenge weren't within 9.3 because they were essentially classic public law grounds of challenge. It may help if we go back to paragraph 9 of the judgment.
Page?
That's at page 3305. I was hoping this, yeah, this is the right passage. So we see there were 64 separate grounds of challenge, which fell into 4 broad categories. The first was about the Habitats Directive, paragraph 10. The second over the page...
So this is a planning, objection to grant of planning
Exactly.
permission, is it? All right.
11 is about compliance with plans, local plans. 12 is about circumvention of ministerial guidelines issued in 2009. And group 13 relates to consent of the landowner. So a broad range of types of legal provision or types of legal obligation, we have there. But then the allegations were essentially that there were public law errors in the context of those various things. So in 178, going back to 3368, we see that the Court of Appeal has said that these are classic grounds of judicial review. You're seeking to quash a decision. I don't think it's sufficiently connected to the environment. Then we have 179, the endorsement by the Supreme Court that 9.3 is autonomous and intended to be given a broad, not strict interpretation, as evident, if nothing else, from the use of the wide and general term relating to. Pick up that Conway case that I've just been discussing. The implementation guide somehow relates to. And then at the bottom of that paragraph 179, the disputed grounds, by contrast, do. So the sentence before says these may in a remote sense, that's the point about the roadways, The disputed grounds, by contrast, do. The legal rules giving rise to these grounds determine how decision-makers must address processes that are both intimately connected with the environment and are intended to ensure the decisions having that connection are reached in accordance with law. The fact that the same principles are applied to other types of statutory decision-making does not change this. And then in paragraph 180, we see the characterisation of the public law principles as ultimately parasitic and as adjectival. And the last sentence, or last couple of sentences of that paragraph are, when the statutory scheme to which they're attached is itself part of the state's environmental law, it follows that these judicial review grounds arise from that same body of law. Each of the grounds in issue here were part of the state's environmental law. So it's said against me that that must mean that that kind of elective venturing into some territory before public law principles arise must be out of scope of 9.3. But I say that's entirely wrong, that the decision maker, even when entering into an elective field, you're in Fewings 3, up to you what you do, is acting in a known legal framework. And when deciding lawfully and compatibly with the statutory regime as construed to take environmental considerations into account, the public law principles arise, adjectival as they may be, to the function of the decision maker and constrain the decision maker in relation to the environment. Now, I don't read these paragraphs as excluding that view of the world. That obviously wasn't an issue in the case. This is a decision of the Supreme Court which upheld Aarhus protection when it had been rejected, which said the courts below had been too narrow, and in fact public law principles do form part.
As I understood these paragraphs, they're upholding Aarhus protection in relation to application of general principles of public law.
They absolutely are, but they're relied on as if it's against me.
Yeah, I agree. So,
but I say
I think you're saying it helps you. Yeah.
It's helpful, exactly that. So there we are.
And you were making the supplementary point that although I think you're saying this wasn't a Fewings 3 type case,
I don't think
that
so.
the reasoning would, you say, extend to a Fewings 3 type situation.
Absolutely.
And that would be on the basis that Fewings 3, it's inherent in a Fewings 3 analysis that Parliament has given the choice to the decision maker to treat something as relevant. And if the decision maker, exercising the power given them by Parliament, treats the environment as relevant, then public law principles apply in relation to that as they apply in relation to other relevant considerations.
That's right. That's right, my lord. So I say the Irish cases help me. And if I move now, with 20 minutes left before I have to sit down, very quickly to the Aarhus Convention Compliance Committee, say something about the Travaux, not least because we have that outstanding application in that regard. And then, if helpful and if not sufficiently addressed already in my written case, I'll say something about the application of these principles to my claim. In terms of the ACCC, you'll know that there's an issue between us about the proper status of the ACCC reports. There may, in truth, not be a world of difference in terms of outcome. But just so I set out the issue for your lordships, your ladyship. The established position, as per Lord Carnwath in Walton, is that the reports are deserving of respect. Everyone agrees that that's the flaw.
Which paragraph?
Of Walton.
Yes. If you don't have it in your press for time, don't worry.
It's 100.
Right. Thank you.
Which is at page 1520.
Thank you.
Also picked up in Austin, I'm frequently referred to, as your lordship knows. Now, in terms of our Vienna Convention structure, that very probably means we're in Article 32 territory if we're thinking about deserving respect. I mean, that's the agreed ground between us. Now, the basis for the argument that they should have greater interpretational force than that, and that they should take effect within 31 sub 3 of the Vienna Convention is that they're presented to the meeting of the parties. And in both of the cases which we're concerned with, the Austria report and the UK report, the findings were endorsed by consensus on multiple occasions. So made in Austria, endorsed, then repeated and repeated, then the Austria findings picked up into the UK decision, endorsed, repeated. Mindful that you may not have the Vienna Convention entirely at the forefront of your minds, though you may, you find that at 4230. We're in our single combined operation, 31.3. There shall be taken into account, together with the context, any subsequent agreement between the parties regarding the interpretation of the treaty or the application of its provisions, and any subsequent practice in the application of the treaty which establishes the agreement of the parties regarding its interpretation. And if we're in there, it's an authentic source of interpretation, so it matters more. There's presently a reference from the Irish courts to Luxembourg on this very point. It's the Save Leitrim case. So if we open tab 134, page 3392. We go to paragraph 37, on page 3395. The question essentially is, emboldened in 31, how do you view Aarhus report when it's been endorsed by the MOP, the meeting of the parties? And we see in 37, the referring court's proposed answer is yes, that it's binding. 2 or 3 sentences in, the very bottom of the page, in view of general principles of interpretation as reflected in the Vienna Convention, the endorsement by the MOP of the ACCC findings regarding Moldova constitutes a development with interpretative significance, should be viewed as a binding interpretation by the parties to the Convention. Also, perhaps of assistance at the bottom of that paragraph, simply because it relates to one of the points which my learned friend makes against me. As a matter of practice, the text of MOP decisions indicates that the MOP, in this case and in cases generally, acts by endorsing the operative conclusions of the ACC rather than by setting up the full text. The referring court's view is that in such a context, to determine what those conclusions mean and why they have been reached, the only method available is to have recourse to the ACCC reasoning and text. Otherwise, the conclusions are just assertions hanging in thin air that a contracting state would have insuperable difficulty in understanding and complying with. Therefore, the endorsement of a conclusion must, in context, involve the endorsement of the reasons for the conclusion. So that's essentially our case. We say they've been endorsed, so they have that elevated status. In the bundles, I won't have time to take you to them, we've got the ILC conclusions on 31.3, so a long and extremely helpful document in both the main bundle.
Sorry, which page?
I've got tab 196, which is maybe of no assistance to you.
No, we need the electronic bundle, please.
I'll ask for the page reference for that.
Yeah.
And from page 3 onwards in the supplemental bundle that was filed on Thursday.
4340 by the looks of it.
Thank you, my lord. And just quickly working through the core points. My learned friend, paragraph 68 of his case, says that you need concordant, common and consistent practice. The ILC view is that you don't. That's paragraph 11 of conclusion 9, supplemental bundle, page 16. The formula is helpful when deciding how much weight to attach, but is not a threshold. You don't need absolute universal agreement. Para 6 of conclusion 10, that's page 17. That gives the example of Loisidou, in which the Strasbourg court held there was uniform and consistent practice, save that there were 2 objecting states. Conclusion 11 relates to decisions of conferences of state parties. Paragraphs 15 and 31 say resolutions by consensus are normally relevant to the establishment of an agreement, but normally wouldn't be sufficient. And conclusion 13, paragraphs 11 to 16, relates to pronouncements of expert treaty bodies, giving the ACCC as an example, and notes that it can be relevant to consider where they've been endorsed by resolution of states parties, but again, you do so with caution. So I accept that this is a mixed picture. It definitely could be high enough, but it may not be high enough. But what I rely on in particular is consensus and repetition, and that would get me into 31.3. But in any event, everyone's paying them respect under 32.
Yes, now you are at your limits of your time. You can go on and eat into your reply time.
I have 15 more minutes.
Oh, I'm so sorry. Yep, you're quite right.
I
I'm
hope
so
I'm
sorry.
not the limit.
I'm so sorry. Yeah.
So I won't open the Austria or the UK reports because you have them in full in my written case. You know the propositions which we rely on them for. In essentially that broad approach.
Can you just give us the bundle references for?
Of course. So Austria, core paragraphs 52 and 55, page 4384.
Sorry, what were the paragraphs?
52 and 55. So 52 posits a broad test including the word impact, and 55 applies that broad test but says that the mere fact that they are regulations which govern trade wouldn't be enough. So by necessary implication excludes collateral impact. Then the UK report, paragraphs 70 to 73, that's at page 4144. Again, this is Austin, so it's a bit difficult for my learned friend and perhaps all of us, given its status.
I'm so sorry, I missed the page number.
Page 4144.
Thank you.
Which includes a consideration of the function or purpose or aims of private nuisance. And of course, Lord Leggett has already expressed his view on that as part of the test. And then says, essentially, one looks at the claim and considers whether it affects the environment in the broad sense of the term. It's said by my learned friend that it can't be assumed simply because the meetings of the parties have endorsed by consensus that they've endorsed all the relevant parts of the reasoning. I say in both of these instances, not only do I support the view and adopt the view of Mr. Justice Humphreys in the Save Lightroom case, but it plainly is the case that one would have to endorse those relevant paragraphs to get to the end result, and they're critical to the reasoning. In both those cases, there were objections of Austria and the UK. But in both of those cases, the objection didn't translate into anything at the meeting of the parties. And of course, they're contested matters. I mean, that's why we have reports. The travaux, I'll take quickly. Essentially, the shape of the genesis of this provision is at the very, very beginning, the first or second sessions, there was a broad provision saying each party shall ensure effective access for the public to judicial and quasi-judicial proceedings relating to matters covered by provisions of this convention, as well as matters related to the protection of the environment, including the provision of adequate remedies. That's at the very beginning. Then there were two options. The two options are at page 3947, 3950. Either no general access to justice provision, or a provision like Article 9.3, but in relation to acts or omissions which contravene provisions of its national environmental law. Now, associated records of the meeting at that time gave rise to a description of the opposing positions of members of the delegations as being no access or access only in relation to specific environmental laws. That's something which Sir James may refer to in his submissions. It's formed part of their case on the way up, that one should read it as if the word specific were included. And I say that's entirely wrong. But really, it's given the death knell as a submission when we get to the change in the language. And you'll have seen this in our written cases and in the judgment of the Court of Appeal, that we went from national environmental law to national law relating to the environment. Now, I say it's a matter of normal English. That is more expansive as a term. The ACCC agrees with me. That's what they said in Austria. They said it's important that the language isn't national environmental law and instead it's national law relating to the environment. 2 points are made in this regard. So one is the language point, which I know you'll be familiar with from having permitted the statement or letter of Mrs. Ogden earlier this week. But essentially, to summarise, the English and the Russian texts changed at the same time from national environmental law to national law relating to the environment. The French text didn't change, so 3 authoritative languages, 2 changed, 1 didn't. In itself, one might think that would be enough to say, well, the changes in 2 of them probably meant something. But it was said by the Court of Appeal, paragraphs 85 to 88, that the French text, which remained the same, allant à l'encontre des dispositions du droit national de l'environnement, changed the same. They said that has a single locked-in meaning, which is narrow. And the fact that that didn't change must mean that the changes to the English and Russian versions didn't do anything. So I say that's a poor point, I'm afraid. I think that isn't a logical way of reading that history. In any event, we now have the evidence filed in support of Friends of the Earth's intervention, page 3972 and 4067, in which it's explained by their translator that both those 2 competing English versions are compatible with the French. And we have Mrs. Ogg, who filed her letter, page 32 and 34, in which she says, in her view, the better, perhaps significantly the better translation of that French text would be national environmental law, but she says there are 3 potential translations of the French. Provisions of national environmental law, then 2, provisions of national law on the environment, then 3, provisions of national law relating to the environment. So there's common ground that the French text can accommodate the English and the Russian. So I say that supports me. You have the application, our application, to rely on the evidence of Mr. Waits and the accompanying exhibit. That's the Ecoforum report. I think it's fully set out in the documents in the bundles. It's in tabs 11 to 18 of the main bundle, which I know is not going to help if you're working electronically. So that's page 200 to 276. You'll have seen that the Eco Forum report is a draft document. It was drafted for finalisation and circulation. This is all set out in the accompanying documents. But it was never finalised and it was never circulated. It explains that...
Well, that seems a rather decisive blow to the attempt to admit it.
It may well do, my Lord. Can I make these 2 points, perhaps? One, the fact that it was drafted for circulation referred to on that internet page, saying contact me if you want the document, means that it's not a purely internal document. And the second point
Right, but is that good enough? I mean, when one's looking at Travo, you need something fairly stable and very public, which can be referred to by everyone that may need to interpret the treaty. Because otherwise, some people are going to think it means one thing and other people are going to think it means something else. Or the meaning changes when it drops off the internet.
I entirely see that, my Lord. Of course I see that. I gently float, and it may be that we don't need to go there, given the obviousness, I think, of the change in language, though, of course, I lost in that in the Court of Appeal. But there is support in at least some of the international materials for internal documents forming an interpretative function under Article 32. It may be that they're not properly classed as Travo, but we see that in the materials. So at tab 192, page 4301, that's an extract from Gardner on treaty interpretation, addressing some of the cases where internal documents have been used.
I'm so sorry, I missed the reference.
I'm so sorry. At 4301, and it's Gardner on treaty interpretation. And he refers to the oil platforms case, also the Heathrow case. Those are both cases where internal materials were relied on. And in ILC conclusions, conclusion 4, which I presently don't have the page reference for, it's referred to by my learned friend in support of a different point in his submissions, page 95. It's the Kazakili Sudoku case, again when an internal expert report was relied on for 32. And we have that decision itself at page 3570 to 3572. So although we're all very used to applying Fothergill, the two criteria of Fothergill, so it's page 11 of the supplementary bundle, that reference to the conclusions. We're used to applying Fothergill. We know, of course, following JTI Polska, Bullseye doesn't apply anymore to confirmatory use. And I would suggest, supported by those materials, query whether public and accessible applies, at least to some category of interpretative material under 32. But there we are. So I say that change it, but language is significant. It's supported by the Travaux. I have, I think, 4 minutes to set out how I say the proper interpretation of 9.3 should apply to my case.
Yes.
So I say I'm comfortably within 9.3 without needing to win on anything like the full scope of what I say the law is.
So first of all, where is your claim from? Where are the claims set out?
So the amended statement of facts and grounds is at page 469. The second PAP response is also of importance in this claim. That's page 729. Summary grounds of resistance, 536. And our skeleton arguments in front of Mrs. Justice Lang are also of assistance. And I apologise for that unhappy description of the materials, but in this case, we applied for
Sorry, where are the skeleton arguments?
Page number.
Are they really relevant? Shouldn't we be able to look at the grounds and see whether they come within our house protection or they don't? We can't have to embark on a long exegesis to get there. The whole point of the test is it
has to be straightforward.
Yes.
No, it has to be straight. Of course, and you can look purely at the grounds. In this case, we apply for permission to amend at the same hearing that we had the Aarhus hearing. So that explains some of the complexity. And we haven't heard back from the other side, including by way even of amended summary grounds. We haven't had detailed grounds, so we don't know what the response is to our principal claim.
But the red grounds are the amendments, are they?
They are.
Yep.
They are. And there's some of the factual...
So, I'm sorry, are these amendments for which you do not have permission?
We have permission.
You have permission,
permission.
Right. So the permission was granted in respect of the amended...
Exactly.
So why can't we just look at the amended grounds?
You absolutely can, my lord.
Oh, OK. Let's do that.
You may find them helpfully synthesised in a skeleton argument, but you may not.
Let's look at the pleading. That's what cases are based on.
No. And so your lordships may well have seen already from the documents before you the shape of the case. In essence, that we have Section 28, which imposes an obligation to have regard to Article 4.1f of the UNFCCC. So we say that's a mandatory obligation imposed by statute related to the environment.
Sorry, where's that in the grounds?
Ground 3.
That ground 3?
Well, it's pleaded as ground 3, but of course, on the approach of the Court of Appeal, we have to kind of start there if we're thinking about how Aarhus applies.
I think it's sub silentio in ground 3.
Yeah, it seems to be sub silentio.
Yeah. Well, of course, because the approach of the Court of Appeal, maybe I should have explained this more or made submissions in relation to this more when I was setting out how things apply as a matter of domestic law. But the approach of the Court of Appeal bolts on to judicial reviews issues which previously were ancillary background matters, of course important, and of course, if one properly understands how the statutory regime works, one should always start in any claim describing how the statute works. But where something has been taken into account, or where a policy has been applied but misconstrued, the reality is that in many judicial review claims, in particular those brought by litigants in person, say, one would simply say, well, there's policy X, and you didn't apply it properly, or this bit of it is incompatible with another bit. And one doesn't have a section, which now one would need to do if the Court of Appeal were right, explaining exactly how it is that one ends up in a position in which the relevant legal error took place. So for us, it is ground 3 because they made an error in relation to the proper characterisation of the UNFCCC.
And you say they had to have regard to that by virtue of Section 28?
I do. And I have permission on that ground, and it's on that basis that Mrs. Justice Lang granted me Aarhus cost protection.
So just focusing on ground 3, was that right?
Focusing on that being the legal basis of the obligation to arise. So that is ground 3 because they made a mistake in relation to it. But it would also get grounds 1 and 2 in.
Right, that's what I wanted to check. Are you relying on the other grounds as well?
Yes.
For these purposes?
So it's really the other way around. I'm afraid I'm making a poor job of the submission. So the Court of Appeal says, just applying the Court of Appeals test, if there's a provision of national law relating to the environment, and imagine that I'm right that Section 28 is one of those, then public law errors in complying with that obligation are in scope. So grounds 1 and 2, which are public law errors in relation to the assessment of greenhouse gas emissions, 1 and 2 take place in the context of ground 3.
Right, so they're brought in alongside ground 3.
Naturally. And if I didn't have ground 3, imagine that they directed themselves correctly, and I'd lifted up ground 3 and I put it at the beginning of my pleadings and said, oh, this is how the obligation arose. That would mean that grounds 1 and 2 are in. On the Court of Appeals approach, assuming I need that bespoke statutory provision and the
so is this now a submission that even if the Court of Appeal are right, they misapplied their own analysis and you should win even on their analysis?
They appear to have misapplied it, but of course they say that Section 28 doesn't count because it's a general provision. So they're against me on whether Section 28 is a provision of national law relating to the environment.
All right, but your main submission, as I understand it, goes much wider than...
Much wider, of course.
Yes.
Yeah,
so,
much wider.
Well, perhaps just explain how this works on your main submission, and we'll bear in mind that you've got this alternative submission.
So on my main submission, my lord, the defendants looked at greenhouse gases. They said there's a section in the impact assessment to which they then had regard, and they said the data is mixed in relation to greenhouse gas emissions between the UK and Australia. So essentially they couldn't form a view, it was mixed. And I say that's a public law error. I say it's irrational, it's an apples and pears point, and you'll have seen, I hope, that the basis for the apples and pears point relates to beef herd and dairy herd. I don't know how much detail it would be helpful for me to go into. But essentially, they were comparing two data sources, the respondents comparing two data sources when they formed the view that the data was mixed. One of those data sources only compares beef herd beef. That is about the same in the UK and Australia. The other of the data sources includes dairy herd beef as well. Most beef here comes from dairy herd beef, and dairy herd beef is much less greenhouse gas intensive.
I don't think we need to look at, if I may say so, this level of detail for present purposes. We just need to understand how conceptually this comes within the... and I understand you to be saying that it does because the defendants themselves chose to look at greenhouse gases and therefore if they got that, if they made legal error in doing that, that falls within the scope of
That's it.
Aarhus.
It's exactly that they were under public law obligations to conduct the exercise they'd embarked on lawfully. Now, they were also...
And you say that covers all three grounds?
It covers 1 and 2, and 3 isn't a public law error. It's a
stronger error.
But plainly related to the environment.
All right. Yes. All right. Thank you.
I've lost 5 minutes from this afternoon. I don't know if I can be of any further assistance.
No, I think we've asked all our questions. Thank you very much. Yes, Sir James.
Yes, my lady. I'm obviously going to be referring quite a lot to the convention itself. And just for your note, the convention starts at page 4004. Did invite you to go there now, but I'm going to have that out. So if you have that, if you have that separate, that might be useful for this afternoon. If you have that in hard copy, because there's going to be quite a lot of reference to that. So 4004 is the start of it. You don't need all the annexes, just the main articles, which is about 10 or 15 pages. The issue is whether the claim is within the scope of Article 9.3 of Aarhus. That's at page 4020. That's not Article 9.3, is at 4020. And that, of course, as you've already seen, concerns a challenge to, quote, acts and omissions, no worry about that, by public authorities, no worry about that, which contravene, and then provisions of its national law relating to the environment. That's the key wording. And you've alighted on parts of that already, focusing on what amounts to national law, what does provisions bring to the party, and in particular the phrase that the Court of Appeal considers to be at the heart of this, and we respectfully agree, relating to the environment. How broad is relating to? Our submission overall is that the Court of Appeal at paragraphs 96 in particular, but also at 151, were correct to conclude that Article 9.3 applies only to and I quote, a contravention of a legal provision which concerns or is to do with the environment, its protection and regulation. So the focus of 9.3 is on the nature or character of the national law in question. That was their conclusion. So you were asking my learned friend how she would formulate her case. She gives you various different ways.
So can I just check, legal provision, are you saying that has to be a statutory provision, or does common law apply
Not necessarily.
Well?
Some common law can be in it,
right.
but it's got to be a provision of that character.
Right.
I mean, we know, for example, that private nuisance, for good or ill, Austin, right or wrong, has been included. So I'm not drawing a common law versus legislation distinction, but I do say it's important to keep focused on what is the nature of the provision. And of course that throws up difficulties if the nature of the provision is as it were, entirely general, throws up difficulties which we'll come to in the Irish cases if the provision of law that you're relying on, or the law that you're relying on, is in effect adjectival and in an entirely general way, operates in an entirely general way. For that purpose, we say, if it arises in the context of an underlying statutory scheme, you look at the statutory scheme, and the question that you ask is the one that at the Court of Appeal we submit correctly posed at 96 and 151. What I was going to do by way of my submissions was to try to put some structure on them. I'm going to start briefly, because they'll be very, very familiar, I know, to the Court, with the principles of interpretation that apply. And the principles of relevance for present purposes are the principles that apply under the Vienna Convention for obvious reasons, because you're construing Article 9.3. So I'm going to start with that, and then I'm going to use those principles, that basic structure, the combined approach as it was put recently in the Supreme Court, but I'm going to use that to break down the submissions and make my submissions under those headings. So I'm going to have language and context as topic one. I'm going to do object and purpose as topic two. I'm going to spend a little bit of time on the travo and matters to do with the travo, which are, of course, subsidiary lines of authority for present purposes under the Vienna Convention. Then I'm going to briefly cover, although quite a lot of it you've already seen and you can read for yourselves, I'm going to cover some of the lines of authority that bear on all of this: foreign, domestic, Aarhus Compliance Committee, including a quite important issue that's been raised with you about the status of compliance committee reports, and then I'm going to try and apply it to our context. So that's going to be the basic structure. I start then with the principles of interpretation, and I probably don't need to do more than to refer you to two recent Supreme Court authorities and give you the paragraph numbers, because they will, I know, be very familiar at least to some members of the court, because at least two of you contributed to the leading judgments in those cases. The first case is infrastructure, and the paragraphs that you want from infrastructure start at paragraph 73 in infrastructure, and that is at page 2531 and following. Again, I'm not going to take you to them now. you've got a little segment where the court addresses the principles of interpretation. I respectfully submit it contains all you need, and it's very helpful, unsurprisingly, having been written by Lord Lloyd Jones and my Lady Simla. So that's infrastructure. The second one is JTI Polska, authored by my Lord Hamlin, and that, for relevant purposes, the relevant bit of that is paragraphs 22 and following. Again, you'll see when you get to the end of it, because the principles stop and the application begins. That's page 2417. As I said earlier, the relevant principles of interpretation for present purposes, which is why those cases are relevant, are the principles that govern the interpretation of international treaties, international conventions, as the Court of Appeal rightly concluded at paragraphs 51 and 52 in their judgment. And as this court has frequently noted, that's the right approach where you're dealing with an international convention, trying to work out what it means when it's come into domestic law. We've given you the references for that proposition, self-evident as it is, in our case at paragraph 18. The structured approach, as you know, is contained in Articles 31 to 33 of the Vienna Convention. And if you want the Vienna Convention in the raw, that's behind page, or that's at, those relevant articles start at page 4230. And they include, as you will well know, Articles 31.1, treaty to be interpreted in good faith in accordance with the ordinary meaning, to be given to the terms of the treaty in their context, in the light of its object and purpose. We've dealt with the relevant parts for present purposes, the relevant parts of the convention and the relevant parts of Article 31 in our case at paragraph 19. Again, I don't think there's anything terribly controversial about that. That's where you find it. And we note that from infrastructure services, the case I referred you to earlier, paragraph 75, see page 2532, that the approach enjoined by Article 31 is, as the court described it, a single combined operation. Probably applies as much to domestic law and the PACAR and all that line of authority. You have a philosophical question about whether purpose comes before language or the other way around, but it's a single combined operation is the way it was put, under which the ordinary meaning is looked for, having regard to context, object and purpose. That's the approach. And then there are supplementary means of interpretation in Article 32. That's where you get into the travo, and again you have some helpful consideration of Article 32 and the travo and everything to do with that. Again, in infrastructure, see for that purpose, for its analysis of how Article 32 works, infrastructure, paragraph 76 and 77, including the emphasis that the supplementary material should clearly and indisputably disclose a definite legislative intention. And I think, as my Lord Hamlin put it in JTI Polska, at paragraph 32, page 2419, confirmation means finding support for a given meaning. Article 33 is the final relevant one in the Vienna Convention, and that takes you into language and different language versions of the same text. That's the bit that governs that relevant consideration. Here, as you know, we've got English, Russian and French as the three equally authentic texts. If you want the reference for that in relation to Aarhus, it's Article 22 of Aarhus that gives you English, French and Russian equally authentic, page 4026. There have been some additional notes of caution sounded in relation to interpreting international conventions, including in particular the point that was put, I think perhaps most clearly, if I may say so, by my Lord Hope in the Hoxha, H-O-X-H-A case, at paragraph 9. We refer to that in our case at paragraph 23. The relevant reference into the bundle for paragraph 9 of Hoxha is 1198. But the point is, real care that the courts exercise not to amend international treaties under the guise of interpretation, for the obvious reason that the parties very often negotiating go to and fro, and they can be taken only to have agreed to what they've actually set out in the final wording. So a domestic court needs to be a bit careful about going too far in interpretation for fear of being taken to amend rather than interpret. And the same point is made, the final point I'll make before the short adjournment, exactly the same point is made about caution in the Court of Appeal's judgment at paragraph 89. My lords, my lady, those were the principles of interpretation that we rely on. Again, as I say, nothing controversial, I think, in any of those, but helpful perhaps to collate them. And after lunch, I'll start, if I may, with the language and context.
Thank you very much, Sir James. The court will adjourn now. We'll resume at 2 o'clock.